It's a nice sunny spring afternoon, and a cool breeze is blowing. You're driving home from work and admiring the beautiful homes as you cruise Sunset Boulevard, approaching the Beverly Hills city limits. Your windows are down, and the music is pounding at just the right pitch through your Alpine S speakers. But suddenly, your sound is interrupted by the ugliest musical note you have ever heard. It's the familiar whoop whoop sound of a police siren. Your car is immediately engulfed in a cloud of flashing red and blue neon lights. You pull over and park. The officer approaches your car and says you blew through a yield sign a few blocks back, then asks for your driver's license. As he leans in to take it, he briefly pauses, slightly pulls his head back, and asks, "What is that odor? Do I smell marijuana?" You sit in temporary shock and ask yourself, what can he do? What will he do? You tell yourself to relax, but you can hear your own heart pounding in your chest. Then you think, forget about him. What should I say? Welcome to the Four Eyes of Law. I'm attorney Larry J. Brookins, a California trial attorney with over 25 years of litigation experience in both the state and U.S. federal courts. 10 of those years were spent with two of the largest government agencies in Los Angeles. As a lawyer, we must give our mandatory disclaimer. This video is for informational purposes only. It's not intended to provide legal advice about any specific case or person, or to establish an attorney-client relationship. As always, our first line of advice, if you're facing a serious legal matter, is to consult with an attorney of your choice. So, let's talk law. California cannabis laws create two lanes on the same road. Lane 1 says that lawful adult possession is protected and legal. In fact, California Health and Safety Code Section 11362.1 specifies that lawful possession of cannabis cannot be used by itself as a reason for police to detain, search, or arrest someone. However, Lane 2 establishes that open marijuana packages, containers, or use while driving is illegal and prohibited. But what about the California Vehicle Code, Section 23222, that deals with marijuana possession in a car? What does it say? The rule is pretty simple. While a person is driving on a public road, they can't have an open container of marijuana anywhere that's accessible to the driver or passengers. That means if the package is open, the seal is broken, or there is loose cannabis flower, a person may be in violation of the law. However, keeping an unsealed package or container in a vehicle's trunk may be legal. Now, there is a very thin line between the lawful possession of marijuana and what constitutes probable cause that a person has committed criminal misconduct. So, let's talk law and try to answer the question of what might a person consider doing if an officer says they smell weed. Tip 1. Stay calm, polite, and respectful. A person's attitude often shapes how such stops unfold. A calm voice keeps the focus on the law. In California, the smell of marijuana by itself is not always enough to justify a search or arrest. Courts have said that odor alone, without other facts suggesting a crime, doesn't automatically give police reasonable cause to search a person's car. In the 1980 case called People v. Johnson, the California Supreme Court said that while smell can be part of probable cause, officers still need more facts to believe a crime is happening, or that evidence of a crime will be found before they can search, detain, or arrest. Such other evidence can be an open container, impairment, or other factors. In another case, People v. Shoemake, decided in 2019, the California Court of Appeal looked at the smell of marijuana, together with the driver's behavior and where the cannabis was found. The court said the smell alone was not enough to justify a search. The point is simple. Odor can be part of the picture, but it doesn't complete the picture by itself. Tip 2. Know the difference between burnt and unburnt cannabis. In the case of People versus McGee, the court made clear that the smell of unburnt cannabis, especially when it is sealed and stored properly, may not be enough to justify a search. But the odor of freshly burnt marijuana, combined with signs of impairment, can change the equation. The courts draw a line between legal possession and illegal use. In California, the smell of marijuana by itself is not enough to justify a search or arrest. Courts have said that odor alone, without other facts suggesting a crime, doesn't automatically give police reasonable cause to search your car. Tip 3. A person does not have to consent to a search. If asked, a person may say, "Officer, I do not consent to any searches." If they search anyway, do not fight or resist. The side of the road or scene of the incident is not the place to do battle. The battleground is a courtroom, with a good lawyer by your side. If the officer goes beyond what the law allows, your attorney may raise that challenge later. Then, tip 4. Store cannabis properly. That generally means if you are transporting cannabis, keep it sealed and locked in the trunk. That simple step removes one of the biggest justifications for a search. Now, before we continue, let's pause to say, if you find value in this video, please pay it forward. Hit the subscribe and tap the bell. This helps other people who need this information to find this video. You'll also have it saved and won't have to search the web again when you want to review this information. Tip 5. Understand the law on stops and the time involved. This rule lines up with the United States Supreme Court's decision in Rodriguez versus United States. In that case, the Supreme Court held that officers cannot extend a traffic stop just to wait for a dog sniff. The same logic applies here. If the only claim is odor, the officer must act within reasonable time limits. Tip 6. Cannabis odor versus suspicion of driving under the influence. An officer may argue that the marijuana odor gave them reason to investigate for driving under the influence. But if all they claim is smell, it may not be enough. However, if they say they observed red eyes, slurred speech, impaired driving, or other reasons, they may be able to extend and expand the stop. California law treats cannabis and alcohol similarly. A sealed bottle of liquor in the trunk of a car may be permissible. An open beer bottle in a cup holder is not. Tip 7. Document the encounter in writing as soon as you can. Note the details. What was said, where the officer stood, what actions they took. If a stop results in a citation or arrest, those details may become evidence for your defense. So, let's quickly summarize the 7 tips. 1. Stay calm, respectful, and do not resist. 2. Know that lawful possession is not a legal basis for a search. 3. Odor must usually be combined with other facts, like open containers or impairment. 4. Do not give consent to searches. 5. Keep cannabis sealed and stored in the trunk. 6. Courts limit the use of odor alone as being sufficient grounds for probable cause. And 7. The courtroom is where a challenge is made, not the roadside or scene. A couple of things to note. There may be special rules or exceptions as to packaging or possession for legally qualified medical patients who have a valid cannabis user's ID. Also, California law limits how much cannabis a person may legally possess. This information is not the subject of this video. However, if we receive enough comments, we may produce a video specifically about those topics. Thanks for watching The 4 Eyes of Law. If you found this helpful, please hit the subscribe button and tap the notification bell. This helps other people who need this information to find this video. Thanks for watching and check out this next video.